The only variable we can't control in that equation is the mind of the person entering the rehab facility.
Thank you. We are back on the record now. In the 8th Circuit Court, taking up next the case of people of the state of Michigan versus Kristen Walker. This is file number 25-1405. FH, appearances, please.
Nate Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Walker. He's joined me at the table in the city to my left.
Thank you. Also here this morning is Ms. Lindsay Simmons. She's an agent from the Michigan Department of Corrections, stepping in today for Mr. Kevin Stapleton, who prepared today's pre-sentence investigation report. We are here today for a sentencing. I'm going to take a quick look here, see if I had any corrections.
Hey there, sorry to interrupt the video, but I wanted to take a moment to let you know that TCF is a channel that is 100% human created and human driven. There's so much AI slop out there on YouTube right now, especially in the LawTube space, that I think it's important to point out that every video that we have here on this channel is human created, human curated. We make all the decisions, we do all the editing, it's all us. So if you appreciate that human touch and that human interaction, please do consider subscribing to the channel if you aren't already. Leave us a comment on the video, put a thumbs up. Those things really help us. And if you want even more human interaction, consider joining us for our live show every weekday morning. Okay, sorry to interrupt. Back to the video.
All right, I did not. On CFJ 284, page 7, number 8 of 11, it appears to be that that offense occurred on January 12th of 2022. The case right above it, he was arrested on June 8th of 2021 and didn't plea until January 26th. So therefore, for number 8 of 11, he would have been on bond. I think the same is true on page 8 for 10 of 11. Look why I thought that. 1 second. Looks like I was wrong on that one, so disregard. We're good. All right, no other changes. How about you, Mr. Carnes?
Thank you, Your Honor. I do not have any changes.
And Mr. Harris?
I don't have any changes to the language.
Allocution?
Good morning.
Morning.
I think if we look at this in the narrow vision, focused vision rather, we see a 0 to 11 case. We see an obvious candidate for 7411, but we see a gentleman who has a problem, likely with alcohol, perhaps with other controlled substances. If you look back through his criminal history, pretty obvious that there's a problem with alcohol there, and it's pretty obvious that he's going to need some intervention to get through that aspect of things, to get that monkey off his back, if you will. The reason I focused so narrowly was because those are facts. He's got 53 days of credit on 0 to 11. The expanded view, unfortunately, shows us that there was an elephant in the room. There was a problem with his bond on this case, and a couple of miscommunications between him and myself in the court, perhaps, that led him to be away from supervision for a period of time here. The only reason I'm bringing that up, Your Honor, is that I think, despite that, I think this case is an outlier. I think his overall track record on probation is exemplary. I think he's had a couple of opportunities to demonstrate to everyone involved that he is a worthy candidate for supervision. Okay, let's get to the next level. Is he a worthy candidate for protection under 7411? I would answer that with a resounding yes as well. And that's in spite of my knowledge of what occurred in this most present matter. I would encourage the court to view it in the same light. There are a number of opportunities that being on a period of probation will afford to Mr. Walker, not the least of which he's already discussed with Mr. Stapleton with regard to perhaps being placed in a treatment facility. Again, I'm always reluctant to raise that flag and wave it around too much, Your Honor, because as you know, everybody says they want to go to rehab. That's why we take appropriate measures within our office. That's why I can state with some degree of confidence that I believe Mr. Walker is an excellent candidate, is in an excellent state of mind psychologically to benefit from rehabilitation of that sort. As I often point out to the court, it's probably obvious to everybody, the only variable we can't control in that equation is the mind of the person entering the rehab facility. We can secure them a bed with their cooperation. Of course, we can, as the court has noted on several occasions, give them a bus ride to the front doors of the rehab facility. We can force them to go inside. What we can't do is force them to benefit from the programming they receive in one of those facilities. I am of the firm belief that Mr. Walker is, and again, I hate to unload the term too much. I believe he's ready to take that step at this juncture in his life. He's now in a position where the use or the consumption of alcohol has imposed such a burden upon him. I understand that's not his recent, this conviction is for possession of cocaine. However, if he had not been in a vastly inebriated state that night, it's very unlikely he would have had police interaction, et cetera, et cetera. No, I'm not condoning the possession of cocaine, but what I am saying to you is that's not the paramount issue in Mr. Walker's life. So much so that I believe he was completely forthright with the court in making his plea. He said, look, yeah, I had a bunch of cocaine that I was using recreationally for whatever that's worth, but I got vastly inebriated and had police contact, and that's how they found it. So I think the key to the Gordian knot that we have here is the use or his consumption of alcohol. And once he addresses that sufficiently, he's had periods of sobriety, but once he gets into a situation where he has programming and training and counseling, et cetera, that will enable him to move forward and not talk about periods of sobriety anymore, but just talk about sobriety as a way of life. I think what you will see is what I see. You're not likely to see him involved in any other sort of criminal activity without the addition of alcohol to that mix. So right now, what we have is an opportunity. We have an opportunity for this young man. He remains a young man, despite his amassing of a fairly substantial criminal history. He's at a crossroads right now. He has to make a decision on how the rest of his life is going to go. He has a young child. He has other employment opportunities awaiting him. He's benefited in the past from being on supervision. I don't see any reason why this case is any different. Moreover, I would promote him to be considered for probation under Section 7411, as this is his first, I hate to say it this way, but I will, his first drug case.
He had one when he was a juvenile, did he not?
He did. He had a possession of marijuana as a juvenile. I think that's considered an adjudication, so we're not making ineligible.
Just want to make sure he's talking about the right thing.
No, I didn't mean to mislead the court, obviously. I disregarded that as having been adjudicated, so forgive my faux pas in that regard. However, I don't think it changes the point that the request that I would make is that the court fashion a sentence that allows for a period of probation, supervision, If that amounts to him being placed in rehab, so be it. If not, he will do it on his own. That's how serious he is about getting on the road to recovery. And he has 53 days credit on the 0 to 11 guideline. I see little utility in returning him to jail, although you can tell, Your Honor, he's wearing red. He has done an exemplary job while serving his time in jail as well. He's used that time to attend programming in the jail. He gave me some sign-up sheets and I must have misplaced them, but I can provide them to the court if necessary.
I accept that.
Yeah.
Thank you.
So he hasn't been wasting his time while he's been sitting in jail. He's proactively participated in at least preparing himself for the path to recovery that he will achieve through rehab. Thank you, Your Honor.
Thank you, Mr. Carnes.
Thank you, Your Honor. As I reviewed this PSI, I just thought this is a real mix of behavior. We had unsuccessful probations on convictions 1, 5, and 6, and successful probations on 2, 6, and 10. I said 6 twice there because they discharged him successfully. It sounds like he was successful in the end, but he had a rough start to that one. He was not good on bond on this one. We had missed tests and then absconding. However, he does have a decent work history. He's been going to AA in the jail. I recognize that too. I think a longer period of probation is certainly necessary here than the recommended 18 months. I'd ask the court to impose that. I can see arguments for and against 7411. He had 2 marijuana adjudications as a juvenile that weigh against him. But again, I said he has been doing AA in the jail. Respect court's decision on that, whichever way you decide to go. I will say, although I do think probation is appropriate here, I wouldn't hesitate to change that to a revocation of probation and additional jail. I hope that doesn't happen, but if violations occur, it seems to be one way to keep people from running into him is to jump and leave, falling into the street, which is what is happening here. It is concerning behavior.
Walker, you have the right to make a statement. Anything you wish to say, sir?
Yes, Your Honor, I messed up. I'd like to get my life together. I have kids. Hearing my little boy tell me that he misses me hasn't happened before, and it has this time. I take full accountability for my decisions. And I would hope that you will see that I'm going to try to do better and impose that on your sentence.
Well, there are a few things about which to be concerned with. Certainly having the young son, concerned for you being able to be there for him as a father as he's starting to approach. Well, they're all important ages, but some important developmental age. I look here and you've done well for the last couple of years on employment. I do see a 4-year gap where there wasn't any employment, and that gives me some concern. I note here you also don't have a diploma, but you do talk about getting you a GED. One moment. What term or condition would that be in probation that's similar? Because I would want to make that a term of condition with probation.
Your Honor, off the top of my head.
I don't see it on there.
No. Yes, no, now that you say that, Your Honor, we don't have a lot of those.
Yeah, anyways, I'm gonna
Yeah.
make it a term or condition that he must enroll in a program and make progress toward his GED,
Okay.
because that's important. You had some failed bond violations here in this particular case that ended up with you in jail. Yeah, and there's some statements here about that you need to focus on recovery and treatment. Let's take a look at your history. In 2016 is when your adult history began. That and your period of juvenile supervision, looks like you made it a couple of years, but even with that first retail fraud, you had a couple of probation violations. One of those resulted in a new charge, domestic violence, that also occurred in 2016. And 3 months after being discharged from that case, the domestic violence, you picked up another charge within a short period of time. You did have a dismissal in 2018, so you made it till 2020. And in that particular case, the drunk and disorderly, you had a couple probation violations. You made it about 8 months after being placed on probation, or you picked up the next set of charges. That included the carrying and concealed firearm. In that, you tested positive for marijuana and alcohol, and you had again probation violation. You made it about 6 months before you picked up another charge, another domestic violence case. When that case was still pending, you picked up another domestic violence case in 2022. Finally discharged from probation. It looks like they only gave you a jail sentence. You made it 5 months before picking up an assault resist destructive police officer. And then looks like you made it about a year before picking up another assault resist a police officer and drunk and disorderly. And then when you were finally discharged from that case in 2024, looks like you celebrated that anniversary by getting in trouble in this particular file. So we've got repetitive bond violations, repetitive probation violations, repetitive acts of violence, and drunk and disorderly conduct. So the sentence of the court is as follows. The sentence of the court is you were placed upon a period of probation for 24 months. That is not pursuant to any deferred program. The court adopts the terms and conditions for probation that are listed on CFJ 145 pages 2 and 3. And I find that those are well suited for rehabilitative purposes. I also find that we need to add the one requiring education. The court assesses a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost, a $1,000 fine, a $300 attorney fee, supervision fee of $30 a month or $60 a month if there's any electronic monitoring. Being that this was not a first felony, I assume there was already DNA available, so there is no additional DNA fee. So now the question becomes, what, if any, additional jail does the court give? Again, based upon the repetitive nature, I find the same bond violations, probation violations, similar kinds of offenses. I find that even though this is an intermediate sanction cell, 11, that there are reasonable grounds, and the court sentences the defendant to 180 days in jail with 53 days of credit. Have I missed anything, Ms. Simmons?
No, Your Honor, we will add that GED condition is 3.1.
Great,
We will add
thank
that.
you. All right, and anything else, Mr. Harris? All right, Mr. Harris is going to bring to you 2 copies of one document. You're going to place your initials on one. Doing so neither elects nor waives any rights. It merely acknowledges receipt of the other copy. This document tells you that you have the right to appeal the conviction and sentence in your case. It's typically done by filing a claim of right to appeal if you're convicted at a trial. Based upon the plea, any appeal must be done by filing an application for leave to appeal. If you choose to file an application and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you can simply dispose of your copy of that document. All fines and costs are due within 56 days from today's date, or a 20% penalty could be added. I don't add that penalty as long as the person's making an effort. And so therefore, even if it takes you the full probationary period, I'm not going to add that 20% penalty. You have the right to be considered for early release from your probation after a year if you've been complying with all the terms and conditions. Do you have any questions today, Mr. Walker?
No.
Mr. Walker, I do really hope that you figure this out. It's a struggle. You're getting to be old enough now. It's about time. Age is not always the determining factor. People make bad choices when under the influence. And I hope that you work on your challenges. Thank you. We're adjourned.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.